Ms. Reyes, how are you?
Okay, how are you?
All right,
Well,
it's the
thank you.
defense's
Couple questions
time.
about State's Exhibit 128. This was the photograph that was shown to you by the Detective Juarez, when you gave your interview in September of 2017, right?
Yes, sir.
And it was the only photograph shown to you of any of the people involved that day, correct?
No.
Okay. Were you shown others of people that might be Mr. McIntyre?
Oh, no, sir.
Oh, I'm sorry. You were shown a photograph of Mr. Bell and of Jeremiah, correct?
Yes, sir.
But when you were asked about Mr. McIntyre, Detective Juarez just showed you this photograph and said, do you recognize this person?
Yes, sir.
Right? You weren't shown this photograph in a lineup with other photographs of other similar looking men, right?
No, sir.
Okay. Now, the photograph in question, you don't know when this picture was taken, do you?
No, sir.
And this isn't exactly the same haircut that Mr. McIntyre had on the day in question, is it?
Yes, it was.
Okay. His hair was this poofy on the day in question?
Yes.
Okay. Are you sure of that?
Yes.
Okay.
You don't
129 you were shown has been admitted, correct?
Counsel,
Yes,
this
sir.
is in regards to a voir dire about State's Exhibit number 128.
Yes, sir. I'm trying to keep it limited to just that. That won't be very long.
All right, so if there is a cross-examination regarding how he looked in State's Exhibit 129 versus 128, that's for cross-examination, not necessarily for voir dire.
Well, I think it does briefly touch on its admissibility. I'll just have one question.
Okay.
Is it your belief that his hair is longer, shorter, or the same length in what's been admitted 129 as it is in 128?
You can't tell because it's on the side.
Okay. Do you know when 129 was taken?
No.
Okay.
Are they gonna try and say that TK wasn't there? Ah, man, this is the defense questioning her. We'll see.
Those are all my questions, Your Honor. I would just object that, number one, it's just a show up of one photograph. It's not a full lineup. I think that's an improper identification question. But it may not be relevant because the witnesses identified Mr. McIntyre in other photographs. Secondly, as the court has pointed out, there's the concern about the fact that it appears to be a booking photograph. And that appearance in and of itself might be prejudicial to the jury, in that it's not just an ordinary photograph of him in daily life. And third, because the witness can't attest to whether when the photograph was taken, I think there are concerns about whether it might improperly bolster other aspects of the state's argument by leading the jury with the impression that this was the length of his hair on the day in question.
But didn't you testify that that was the length of his hair on the day in question?
Yes, I understand that's the witness's testimony, but those are my objections.
All right. Well, with regards to State's Exhibit number 128, State, I'm going to ask that the portion that states that that is from the San Antonio Police Department,
Yes,
that portion be removed.
All right. If I could just,
You okay, Cindy? And then with regards to your saying that it was only one photo shown to her.
Struggling.
Yes, Your Honor. I mean, I think the court has fashioned a remedy that solves the other objections.
I'm sorry, are you withdrawing your objection?
Well, I am objecting to the exhibit as offered, but the court has suggested it would admit an exhibit if the San Antonio Police Department and the signature line of the witness identifying him on the specified date are removed.
No, that's not being removed. The only thing that would be removed would be the portion that says it's the San Antonio Police Department.
I see. Then yes, I maintain my objection that it's a single photograph. The witness was not given the opportunity to identify Mr. McIntyre of a lineup of similar individuals. It was instead just shown a picture of the person that the officer had pre-printed and asked to sign an initial. And I think that kind of a lineup procedure is suggestive. It's a pre-indictment or pre-arrest Mr. McIntyre lineup, so there's no objection to the fact that there wasn't counsel present. But I think that the method of employment here has been discouraged as being overly suggestive because it doesn't give the witness any ability to discern.
But if somebody knows someone, do they need a lineup of several people if they've been in their life? For example, just hypothetically, if someone presents a photograph of someone's mother, do they need a lineup of people who look like their mother for them to identify a photograph as their mom?
Well, I would completely agree with Your Honor, which is the third part of the objection, which is that it's overly cumulative. We already have photographs of Mr. McIntyre in evidence, and she has personally identified him in the courtroom without any objection from the defense. So there's no need to have this photograph at all.
All right, the objection is going to be overruled. State's Exhibit number 128 will be admitted with the following redactions. the top portion that states San Antonio, I believe it states San Antonio Police Department.
Yes.
That needs to be removed. The emblem of a badge, that needs to be removed.
Yes,
And I
ma'am.
believe that's in the top left corner. Yes.
Judge, if I may, I just was trying to find out exactly how the court would like us to do it. One, to expedite it, we could cut the top portion off, and that would, I mean, of course, I'd have to re-sticker the 128 if there's no opposition to that.
If you can just, if there's no objection, cut that portion off and then just have another sticker label and you can put the sticker at the bottom or wherever. So if y'all would do that.
Yeah, Judge, I have two more that I'd like to get in, so since we're outside the presence of the jury.
Let me see what two they are. All right, and with regards to this as well, the top portion, and if you want to show it to the defense.
And Your Honor, one other, as to 128, the only other objection that could be hearsay as to the written portions beneath the photograph.
It looks like, it gives the impression of a mugshot with the signatures at the bottom. They don't add anything since she's identifying it as him.
Let me see the bottom of it, please.
The larger concern, Your Honor, is that obviously Mr. McIntyre has a prior arrest in Fort Worth for a homicide offense, which is a worry of 404B concern that the state has indicated.
This is what I'm telling everyone. This photograph is coming in. Now, here's my question. With regards to this writing on the bottom, where it says Tamar Trayvon McIntyre, who's written that?
May I see that?
If that's writing by someone other than this witness, then that needs to be removed as well.
All right, if I may just, I believe it's her.
If you'll ask questions on the record.
Yes. Ms. Reyes, I'm showing you what has been marked as State's Exhibit number 128. This line that I'm pointing out where it says name of person identified, whose handwriting is that?
It's mine.
And where it says sworn to, whose handwriting is that?
I believe in detectives.
Okay. And the signature line, whose handwriting is that?
Mine.
And the date line, whose handwriting is that?
Mine.
Okay.
All right, so I'm sorry, which?
So she stated that this portion was by the detective, but everything else is by.
His name, Your Honor.
No, the witness has stated that the name that is listed, that's written there, that's her writing.
Right, but that's poultry, and she's testified to it. We don't need to, that is still hearsay. It's a prior consistent statement. Nobody is contesting that she's identified it. There's no need for the additional hearsay. It just serves to bolster.
Judge, it's not to bolster, it is to prove identity that they've been contesting the entire trial. And so I believe that it's permissible for us to offer that into evidence to show that she is the witness that observed the photo and personally identified the defendant back on the date that she conducted the ID.
And she's done that before the jury. There's no reason to have the written bolstering, which is hearsay.
And we haven't, I mean, while questions of identity are contested, there has not been any contest that this man is named Tamar McIntyre. And it isn't disputed that these two people know each other.
And that she's testified.
So the question as to whether or not she can identify a photograph of Mr. McIntyre is not relevant to any of the things that are in dispute.
Judge, it's relevant because in their opening, they were contesting many aspects of the case, but however, one of the things that they heavily contested was that the case was very old. Mr. McIntyre does not appear in the same form as he did back in 2017. And so that is the purpose of it being offered for identity, that this is the same defendant that was in her car.
All right, with
I'll
regards to
tell you
State's
it's the
Exhibit
same
number 128, the defense's objection will be overruled. And then what are the other two exhibits?
They're of the same book.
And defense, it's State's Exhibit number 130 and 131.
Yes, Your Honor.
Now, would you like to order the witness with regards to those?
Yes, just briefly, Your Honor.
Sure.
Ms. Reyes, you've been shown 130 and 131?
Yes, sir.
Okay, and you've identified these photographs as one of Jalen Bell and one of Jeremiah Rodriguez, correct?
Correct.
And again, similar to what we talked about with 129, 128, I'm sorry. These are the only photographs of, that you were shown when you asked for each of their identities, right?
Correct.
You were not shown a lineup for either of these people.
No.
Okay. And to be fair, you know Jalen Bell, you know him from prior interactions, but you've had fewer interactions with Mr. Bell than you have with Mr. McIntyre. Fair to
The
say?
same amount.
Same amount? Okay, and then Mr. Rodriguez, you said you were acquainted with him in high school, but that you all didn't hang out a great deal.
Correct.
Okay. Your Honor, my objections would again be these are suggestive. They're lineup photographs, and we would similarly object to hearsay and bolstering the way we did for.
All right, with regards to those two exhibits, and I'm sorry, what are the numbers?
130 and 131.
With regards to 130, 131, the objection will be overruled. All right, Deputy, you would have the rules, please.
All right, we got that situation figured out.
Now, Ms. Reyes, I'm showing you what has been marked as State's Exhibits 130 and 131. Do you recognize these documents?
Yes, ma'am.
And regarding both of the documents, is this your name?
Yes, ma'am.
And is it your handwriting?
Yes, ma'am.
And is this a fair and accurate depiction of what was shown to you by a detective with the San Antonio Police Department back on September 5th of 2017?
Yes, ma'am.
At this time, Your Honor, the state offers State's Exhibits 128, 130, and 131.
Same objections, Your Honor.
All right, defense, your objections are noted. States Exhibit 128, 130, and 131 are admitted.
Permission to publish, Your Honor.
Granted.
Ms. Reyes, regarding State's Exhibit 128, can you explain to the jury what this is?
Tamar McIntyre.
And
Is
is
that the
that
wanted poster?
appearance of Tamar McIntyre in State's Exhibit 128 how he looked back in 2017 when the offense occurred?
Yes.
Regarding State's Exhibit number 130, can you explain to the jury who that is?
Jalen Bell.
And regarding State's Exhibit 131, who is that?
Jeremiah Rodriguez.
Now, earlier in your testimony, you testified regarding fear that you were experiencing. Can you describe the relationship that you had with Tamar McIntyre to the jury?
It was a
I'm
possession.
going to check relevance and if we could approach the bench.
All rise for the jury.
All right, everyone, please be seated. All right, so this is a hearing outside the presence of the jury. The defense states that they believe that the answer is going to elicit 404B information. So, first of all, state, if this is going to be 404B, has the defense been given notice?
Well, Judge, they were given notice of it in the previous testimony that the transcript that was provided to them, that this testimony is contained therein.
Oh, please be seated.
And in her statement that she gave back in 2017.
They have not filed formal notice to answer the court's question. But, certainly, just parts of it are discussed in just vague terms in the transcript.
All right, so let's do this. Let me hear your questions, let me hear her answers, and then I'll hear objections.
All right. Ms. Reyes, without going into specific instances, can you just briefly describe the dynamic of the relationship that you had with Tamar McIntyre?
He was possessive and abusive.
And when you say possessive, can you explain how so?
Anytime I would enter a room, if there was other men in the room, he came to sit on his lap. I had to wear his clothing down to his underwear.
And when you say abusive, can you further explain that? Well, I'll just move on from that. That's it, Judge.
All right. Do you have any questions in regards to that subject matter? And then I'll hear whatever objections you have.
Well, Your Honor, I guess that question and that answer would not actually be 404B because there's no elicitation of a specific instance of conduct. So it's just character evidence generally. those traits of character are not relevant to the questions that the trier of fact have to answer, which is whether he intentionally and knowingly killed Mark Anthony Saldivar in furtherance of a burglary or a robbery. And so I don't think that it's proper character evidence. I don't think that the predicate has been laid. I don't think it's relevant. And so I would like the court to exclude it on that basis. If the court disagrees, then I would like to engage in some questioning to try and determine whether or not, because the problem with the way that this is set up is the prosecutor is just asking generally, is Mr. McIntyre a possessive bad boyfriend? Is he aggressive with you? Does he put you in fear of your life because of the way that he acts around you when you see other men? And the only way for us to cross-examine or impeach that line of discussion is to go into specific instances of conduct. And so it's almost a bait and switch the way that that's being proposed, which is why, I really do believe that's just not admissible character evidence. It's not an impertinent trait of character for the offense, and there's been no foundation as to why it's relevant.
Let's start this first. Why is it relevant?
Judge, well, it goes to her credibility, and that was attacked by them in their opening statement. And so the reason that the state is offering it is to prove, well, not to prove her credibility, but to lend credence to her credibility and rebut their opening statement regarding their attack on her credibility.
That's just 404A1, prohibited use. That's explicitly what the rule is designed not to allow them to do. She was being paid.
Well, Judge, they argued in their opening that she was being paid off for this, and so I think this line of questioning and testimony goes to something that they're about to attack on their cross-examination as to why she didn't speak out in the months between the offense and when she gave her statement in September.
I don't think anything in our opening automatically would authorize them to violate 404A1.
So what the court is going to do with regards to this line of testimony, for a moment, the court is going to sustain the defense's objection, and if the door is open to something else, then the court will hear it. So,
thank you, Judge.
All right. Thank you.
All right, let's bring the jury in.
Bring the jury back in.
I guess, Your Honor, just to avoid three.
Here we go.
It's still your witness?
Now, Ms. Reyes, I'm showing you what has been marked as State's Exhibit number 118. I'm going to take it out of its envelope. Do you recognize this?
Yes, ma'am.
What is it? Well, have you listened to the contents of this disc?
Yes, ma'am.
Okay, and regarding the defendant, were you familiar with him back in 2017?
Correct.
And have you spoken with him on multiple occasions?
Yes.
Would that include in person and on the phone?
Yes.
And when you listened to the contents of State's Exhibit number 118, did you recognize the voice that was making the call on State's Exhibit number 118?
Yes.
And whose voice would that be?
Tamar's.
And if you pass the witness to him.
All right, defense, you may proceed.
Good afternoon, Ms. Reyes.
Hello.
So, let's start off with your plea deal in this case. You pled to tampering with evidence, correct?
Correct.
That's a third-degree felony?
Yes, sir.
What is it that they said you tampered with?
Ooh, here we
The
go.
car.
The car?
Yes.
Okay. And in exchange for that, you got the capital murder charge pending against you dismissed, right?
Correct.
And you were allowed to remain out on bail this whole time, this past 7.5 years, right?
Correct.
And the agreement is that if you satisfy the terms of your deal, then you'll get what's called deferred adjudication, right?
Correct.
And you understand deferred adjudication means that you would not be finally convicted of that felony offense, tampering with evidence, right?
Correct.
Which means that if you successfully complete your deferred adjudication, you can petition a court to non-disclose the record, right?
Correct.
Meaning that other than police and perhaps the judge, the members of the general public that might want to employ you or give you an apartment or anything else would not necessarily know that you were ever convicted or never admitted guilt to deferred tampering with evidence, right?
Correct.
Okay. And the condition for you getting this deal was that you would testify truthfully against Mr. McIntyre, correct?
Correct.
And you understand when they say testify truthfully, that the person who decides whether you're being truthful is the district attorney's office, right?
Correct.
So if they think that you're not telling the truth, then
There
they
you
would be
go.
able to tell the judge that, and it could impact your case in a negative way. You understand?
Yes, sir.
Okay. And you also understand that if you are placed on deferred adjudication, you're eligible for what's called early termination of that deferred adjudication, right?
Correct.
And early termination can be applied for the day that you are placed on deferred. You understand that, right?
Yes, sir.
So it means that if you testify to the prosecutor's satisfaction in this case, and you are sentenced to deferred adjudication, as you said in your agreement, you could apply for early termination that day. You understand that?
I'm gonna object as to
This is the problem with paying off a witness, right? You do all this, you get him to testify for an incentive, and then the defense comes in and say, so you're going to say whatever they want you to say, right? But still, I mean, is her testimony believable based off of the other witnesses we've heard? It's going to be tough.
On deferred. You understand that, right?
Yes, sir.
So it means that if you testify to the prosecutor's satisfaction in this case, and you are sentenced to deferred adjudication, as you said in your agreement, you could apply for early termination that day. You understand that?
I'm going to object as to relevance. It's a misstatement. He needs to read the agreement because that's not what's contained in therein.
Your Honor, it's plainly part and contemplated of what a deferred adjudication is, and she knows what early termination is.
But is it a part of the agreement? That's the state is saying that it's not a part of the agreement.
Doesn't the agreement say that there's no opposition to it? You have 160. 160.
All right, let's see the agreement, because I doubt he's thinking of another client. This guy's pretty good at his job.
Okay, so let's call your attention. Can we do the Elmo work?
It's ready. It's ready.
She's seen it, so.
Yes, 9 and 10. Yes.
Here we go.
All right.
Oh, this is getting good.
On paragraph 9, it says the state will agree that at any time served on bond while awaiting sentencing, without violation of bond conditions, will count towards the deferred recommendation time, and the state will adjust the recommended time for deferred accordingly. For example, if your client, or you in this case, spends 2 years on bond from this date without violating the conditions, the state will recommend 8 years of deferred instead of 10 years at the time of sentencing. You read that part?
Correct.
And how long have you been on bond for this case?
Almost 8 years this month.
Almost 8 years this month. So the result of that is that if you have satisfied the state's expectation that you testified truthfully, at the conclusion of this, I guess you'll have to spend another year on deferred adjudication before you'd be eligible to request that you receive early termination. You understand that?
Correct.
I'm going to object to speculation and relevance.
Well, paragraph 10.
It's very relevant.
Well, Your Honor, I'm just asking her what her understanding of her own plea agreement is, which goes to her bias and motivation.
That's
which is
fair.
an admissible
Fair
question.
What do they need to approach for? She signed it. This is what she agreed to. He's asking her what her motive was for testifying, especially since she waited to go to the police. This is good. I like this line of questioning from the defense.
That's right. So just to go back to paragraphs 9 and 10 of your
It's another
agreement,
Woody deal.
you understand you've been on bond for 8 years, right?
Correct.
And you understand that under this agreement, so long as you're testifying to the prosecutor's satisfaction, they're promising to give you a discount on the total 10-year period of deferred for each year you served on bond in their recommendation to the court for punishment, right?
Very true. Correct.
And that you must spend half of the total time on your deferred before you can apply for early termination, right?
Correct.
And that would only be a year, given that you've already spent 8 years on bond, assuming that the prosecutor does recommend that reduction and assuming the court accepts it, right?
Correct.
Okay. And you understand that there is no statute of limitations for capital murder, right?
Correct.
And so if you testified in a way that was not to the prosecutor's satisfaction, you understand that you could still be prosecuted for this capital murder offense, correct?
Correct.
And you understand that 10 years is the maximum for the third-degree felony, correct?
Correct.
But it would be life in prison without the possibility of parole for you if you were to be charged with this capital murder offense, right?
Correct.
Okay. Now, when you first met with Detective Juarez, it was in
Interesting.
September of 2017,
Hey, thank
is
you,
that
Dr.
right?
EJ.
Correct.
So about what, is that, I'm not good at math, like what, 6 months or so after the offense?
Correct.
Okay. And during that time period, you said that you went to Dallas, you were in Ector County, which is Odessa, for a little bit, that's where you got arrested?
Correct.
Okay. So you said that you met Tamor about a year and a half prior to this offense?
Correct.
And he was 15 years old at that time, wasn't he?
I didn't know his age at that time.
Well, I'm asking if you know that now.
Yes, no, I did.
He was 15
Yikes.
when you first met him.
Correct.
And he was 16 years old on the 23rd of April in 2017, right?
He lied at that time and said he was 18.
But you understand he was 16 years old, right?
No, I do, yes.
Okay.
We knew this was coming.
You met him at a gathering through Isaac, which was your boyfriend at the time?
Correct.
But then you started dating Tamor in the 2017 timeframe, correct?
Correct.
Dang.
And
Oh, God.
you said that you
Cooking
were
her.
acquainted with Jeremiah Rodriguez because you went to high school with him?
Correct.
So you knew that Jeremiah Rodriguez was a drug dealer, right?
Correct.
And you knew that he often carried weapons, correct?
Correct.
Okay. You said at the time period you were dancing at a strip club?
Correct.
And the weekend of this incident, I believe, coincided with the Stoners Holiday 420. Is that right? April 20th,
Objection, relevance, and lack of personal knowledge.
if you know.
Relevance.
Well, I'm trying, the relevance is, I believe, what they were doing at that party as it relates to what happened later, and it relates to,
All right, show me the time foundation with regards to time.
was there a party the weekend of this incident that you attended with Mr. McIntyre and others?
That weekend, no.
Okay. But you and Mr. McIntyre and Mr. Bell were all hanging out?
We were together, yes.
Was Jeremiah with you?
Yes.
But you weren't staying at Jeremiah's house that night before this incident, were you?
Yes, we were.
Okay, are you sure of that?
Very sure.
Okay. If Jeremiah disagrees with you, Jeremiah is not telling the truth?
Correct.
Okay. And you all took drugs that night before, didn't you?
I didn't, they did.
Okay, well, you say you didn't. Let's be more specific. They took LSD, didn't they?
Yes.
And you didn't take LSD.
No.
You smoked marijuana, though, didn't you?
I was completely sober.
You didn't smoke marijuana or do cocaine?
No, not the day before.
Are you sure?
Yes.
But you had done them in recent time frame.
Previously, yes.
Okay. And so, Mr. McIntyre and Mr. Bell would have taken the LSD sometime in the evening hours of Saturday night before this event on Sunday, right?
Correct.
Okay. And do you have any experience with taking LSD?
Yes.
So you're aware it's a very long-lasting drug, right?
Correct.
So it may not be that they were acutely intoxicated, but there would still be effects 24 hours later. You got it?
Objection, speculation.
In your experience, you can still be having effects from it 24 hours after the fact, right?
Yes, but it didn't seem like that.
Okay, I'm not asking you what it seemed like, I'm just asking what your experience with that drug is.
Yes.
So, that night before, there had been a conversation about a photo shoot. Part of that was to promote your career as a dancer, wasn't it?
No.
Okay? You say it was because Mr. McIntyre was wanting an album cover.
Correct.
But you're aware that Mr. McIntyre has a producer and that he has people that do photo shoots for him and that all of those types of
Objection,
things? If
relevance,
you know.
and speculation.
The state is objected to relevance.
Well, it's relevant because I'm just asking her if she's aware. It goes to whether or not she understood the framing of this correctly.
All right, that objection will be sustained.
So, you contacted Mark through Instagram, right?
Correct.
And Mark had contacted you previously on a different Instagram account of yours, right?
Correct.
And had asked if he could take photographs of you, right?
Correct.
And the kinds of photographs Mark
Objection.
wanted to take to you, I'm sorry?
I'll let you finish the question.
The kinds of photographs Mark wanted to take of you were either nudes or risque photographs, wasn't it?
Judge, I'm going to object, and if we could approach, please.
Oh, man. Jeez, she is holding it together though. I see y'all giving her props in the chat, but oh boy, this is wild.
Ago, Mark had reached out to you on a prior occasion, and the discussion was about whether he could
Jeez.
take nude photographs of you. Do you recall that?
Yes.
And when you looked at Mark's Instagram page, you saw that most of his photography work was of that variety. It was naked pictures.
Yes.
And because of those things, you had blocked Mark previously, right?
Yes.
And then you had activated a new Instagram account, and that's how Mark got a hold of you on this occasion, right?
I had that account for a while.
Okay, but he resurfaced as an Instagram correspondent
Correct.
on a new account, right?
Correct.
And on this occasion, the discussion was displaying you in lingerie, correct?
Yes.
And so those were the circumstances that were going on during the evening hours of Saturday leading up into Sunday. We're making arrangements to have this photo shoot where you would be in lingerie, correct?
Correct.
All right. And you said, I believe on direct examination, that he had agreed to do this for little or no pay, right?
Correct.
And so you all were thinking about doing the shoot somewhere near the North Star Mall?
Correct.
Okay. And when you arrived, he walked out from his house and he got in the car and he saw that it was you, Jalen, Tamor, and Jeremiah, right?
Correct.
And that wasn't something you had explicitly discussed with him before, was the fact that there'd be other men there, right?
He knew Tamar was going to be there.
You didn't know anybody else was going to be there, right?
We said multiple people.
Okay, when did you tell anybody that?
With good text.
Let me
And we
back up.
communicated with him.
Let me back up a moment. You have given statements to the police in conjunction with this case, right?
Correct.
Y'all are
You have
saying
given
she set
statements
him
under
up?
oath when you entered your plea of guilty to the plea agreement, right?
Correct.
And you didn't tell anybody that you had explained to Mark that there would be a bunch of men present at the photo shoot, did you?
No.
Okay. So Mark gets in the car, and immediately, once y'all are rolling away, the photo shoot's called off, right?
He asked to reschedule for a later time that day.
Okay, that's calling off the photo shoot, isn't it?
It's rescheduling.
Okay, so y'all were still driving away with him, right?
Correct. He asked for a ride to North Star.
And you told the detective that you were confident Mark's intention was to have sex with you that day, right?
No.
You don't remember telling the detective that?
No.
What?
Refresh your recollection to look at your statement to the detective?
We can.
Defense is breaking it down. Just trying to get that money. Dang.
Make sure it's back.
No. Excuse me, ma'am, which number are we on, defense exhibit?
Number 9, I think.
Number 9. All right, Ms. Reyes, I'm going to give you this transcript. I want you to kind of look it over. And if you have any questions that you would like to refresh your recollection from it, please let me know. And then I'll be asking you some questions from it too. We'll have a copy for both.
Judge, I'm going to object to that exhibit. It's not a witness exhibit.
I haven't offered it, and I'm just giving it to her because she said it might refresh her recollection, and if it doesn't, it doesn't.
She doesn't even know what it is. I don't even know what it is. I don't know who the
I was just
author
getting you a
is.
copy.
I'm
Okay.
objecting to lack of foundation. It's not her own
I'm giving you
statement.
a copy of it so you can tell me what it is. What do you mean it's not understood? It's on recording. Yeah, that's on recording. I'm not offering it. It's just content. It's just content. All right. Ms. Reyes, if I...
A party's approach.
Dang, man. The defense knows they have to hit it on the head with this witness because, I mean, if they don't, this could look crazy to the jury.